Hello, inventors and innovators. I'm patent attorney Jason Rosenblum, and today I want to guide you through the exciting journey of patenting your invention. If you give me the next few minutes, I'll help you identify where you are in your patent journey and what steps make the most sense for you at this point. So there's several stages to the process, and understanding them will be crucial to your success. So let's dive right in. Phase one is you have an idea. Ideas themselves are not protectable. Inventions are. And to kind of help you understand that, if you think of a flying car, that's an idea. But how you're going to make it fly, the different way the thrusters and steering are going to work, those are probably patentable inventions. We generally suggest at this first stage, when you just have an idea, is to really figure out, is this something you want to move forward with? Creating a product, patenting the product, it's going to take a lot of time and money to do that. So you have to really figure out, is this worth your time and your money? So you should do your business due diligence. And by that, we mean looking at competitors. What's the market landscape like? What would it cost to make a product like this? If you can figure that out at this stage. And maybe even, doing some sort of market research, such as putting up like a Facebook ad for something similar to see how many people sign up that they'd be interested in this type of a product or a service, things like that. But of course, be very careful with what you say in those posts because you don't want to give away your invention, and I'll discuss this a little more later on. So stage two is you have the idea, you feel that from a business perspective there's something there, but you don't know how to take it from idea to invention, and you need the help of product designers, engineers, maybe even manufacturers. Something you want to then have is to be able to speak to those people is a non-disclosure agreement. If you don't have enough yet to file for an application, then you'd want a non-disclosure agreement. So whoever you speak with, you would know that whatever you disclose to them would be protected. Then, once you have enough to really understand how the invention would work, we always suggest a patent search. This is a search to see what's out there. Just because something is not publicly available on the market does not mean that it wouldn't bar you from getting a patent. Because basically everything that's known is what bars you from getting a patent. It's called prior art, and that could be any publication, any prior patent, anything that's known, a blog post, a video that's out there. If it discloses your idea, your invention, that could bar you from getting a patent. So once you get past that stage and you're ready for patent, we see that there is a commercially viable choke point. And what I mean by that is that it looks like you're going to get broad enough patent protection if we move forward and we prepare and file an application. Not everything is patentable, or not everything is worth patenting. It's an expensive process. To enforce your patent is expensive. And if it's very narrow, you might be better off taking those funds and that time that you're going to spend patenting it and putting it toward making the product better, putting it towards marketing. So that's why the search is so important, because without that, we don't really know that. Plus the search, if you're at the stage where we're drafting an application, the search helps us draft a much better patent application because we know what the examiner is going to come back to us with. We know where most of the minefields are so that we can get around them and consider that in our drafting. Then you're ready to file the application. Maybe you file a provisional if it's something you're still working on, you're still perfecting the product. So you might just file a provisional first because that gives you a 12-month window to improve the product. Maybe go to investors, try and get investors, pitch some people at that point, knowing that you're protected, you're patent pending once that provisional is filed. But in order to get a patent, you actually have to file within 12 months of that filing a non-provisional application. And that's the one that would ultimately be examined and turn into a patent. Now, this stage, this last thing that I'm going to give could go anywhere in this spot. But what happens sometimes is clients come to us and they're about to go to a trade show. They're about to give a talk. They're about to go launch a Kickstarter. And there's no time to maybe even do the business due diligence. Maybe the Kickstarter is the business due diligence. There's no time to do a search. We at least suggest getting a provisional file to lock in that date as the date that you had, the ideas, the inventions that were being disclosed, but also that stops the clock ticking for having to file foreign. It gives you protection that if you do decide you want to have protection in foreign countries, you would be able to have that, as well as it stops the clock ticking in the US for when you would have to file that. So, we're here to help you on your patent journey. Due diligence, both from the business perspective and from the legal perspective, is what we really believe in is the right process, and that's what I discussed in my book, which you can get you'll have an offer to get a copy of for free. And I welcome you to sign up for a call so that we can speak and really figure out what steps make the most sense to you and your business, because everyone is different. These are just some general guideline stages for you to understand, but every business, every invention, every inventor is in a different stage that there's something that can be uniquely tailored to you. So thank you for watching, and just click below to sign up.